Gentlemen, we are going to do Chapter 12, Section 3 today, and I'm going to go ahead and start out with a disclaimer that'll probably get some people to stop the video. This is going to be a bit of a beefy one, in the sense of I don't want it to sound like it's an overwhelming amount, but there is a lot of information, and we're going to have to kind of jump around a little bit at times, kind of jump back, cover stuff. It's just a lot, so please pay attention. Again, the court system is not as clear-cut as some people want it to be. A lot of Americans assume if you have a problem, there's like an appeals court, and if you don't like them, you go to the Supreme Court. The federal court system is a little more complex than that, as you guys will find out, and we will then do a little deeper delve into the inner workings of the Supreme Court. So, all that being said, let's get going. The third article of the Constitution is the one that outlines the judicial branch, and funny, there's only one court actually mentioned in Article 3, the Supreme Court. That's right, the only court that the federal government was required to create by the United States Constitution was the Supreme Court of the United States. Now, thanks to the Judiciary Act of 1789, other federal courts were created when the original Supreme Court was designed. Eventually, Congress created several lower federal courts, actually two types. They created a number of them, but there are two types. There's the constitutional court and the legislative court system. A constitutional court is one that basically does everything the Supreme Court does, but at a lower level. It does not have purview or jurisdiction over the entire country. Okay, so a constitutional court judge is like a Supreme Court judge. They are a federal judge appointed for life. They must be confirmed by a vote by the United States Senate. They have, lifetime salary that can't be reduced. They can't be fired. They can only be impeached. I mean, all that good stuff, right? Now, the most important of these are the district courts and the courts of appeals. And that's this is where, I'm sorry, I apologize. This is where having Judge Tapar is sometimes nice, because he last time rattled off some stats explaining, how many cases he rules on. And being an appellate court judge, you get a feel or a sense of just how really and truly these courts are the ones that are doing the work, because only a small fraction of the cases from these courts ever reach, the Supreme Court. In order to get to the Supreme Court, first of all, there has to be an appeal from one of these. But again, very few cases make it to the Supreme Court. So really the bulk of our federal court work is being done at these lower levels. But district courts, there are a total of 94. Every state has one, minimum. Some states obviously have more than one. The District of Columbia has one, and Puerto Rico has one. But then you also have the 11 courts of appeals. There is a regional court of appeals for there are 11 regions, I should say. There is also one in the District of Columbia, and one for the Federal Circuit. Okay? Now, there is another form of constitutional court. There are some specialized constitutional courts, like the Court of International Trade. Now, there's another type of federal court that was created, another type of federal judge created by the United States Congress, a legislative court. Legislative courts are created for some sort of specialized purpose. You are appointed to a legislative court for a fixed term of office. It's like you're elected, right? You're only there for a certain amount of time. You may be removed ahead of schedule, and you may have your salary reduced. So you are not near as safe or prestigious as a constitutional court judge if you're a federal legislative court judge. Examples of legislative court judges: the Court of Military Appeals, the various territorial courts. Here, your book had a little example of the flow of the courts, but here you go. Here's a really confusing diagram that'll give you a better idea of what I'm talking about. This is the federal court system. So as I said, these are, district courts are constitutional judges. U.S. Circuit Court of Appeals is a federal judge, or excuse me, these are all federal people, but The U.S. Court of Appeals is an example of a constitutional judge. They are an example of a constitutional judge. So there you go, constitutional judges. Oh, and I said the Court of International Trade. There you go. There's a constitutional judge as well. I think the Court of Federal Claims is also one. Anyhow, these people are all federal constitutional judges. They've got that lifetime thing, can't be removed, lifetime guaranteed salary, all that good stuff. Now, here are some of those other courts I mentioned. These are also federal courts, but they are a different beast, right? The U.S. Courts of Military Review, the U.S. Court of Appeals for the Armed Forces. By the way, there's one for each branch of the military down here. There's the Veterans Board, the IRS. These are all examples of federal judges or federal courts that you've never heard of because they're not constitutional, like the U.S. Supreme Court is per se. You know, there are these various administrative agency offices. This is not one. Okay, this is a catch-all. Just like there are 12 district courts, 94 district courts, and there are 11 circuit court of appeals, and there's the one federal circuit one, but there are a number of these, right? So you've got this is a catch-all, is my point. There are perhaps a few dozen of these. They are just kind of listed as one big blah. Okay, so here you go. Here's a little more confusing diagram of the flow of how these appeals take place. Really, it has to do here with where it's occurring, I would say. If it's occurring in the District of Columbia, specifically, it's going to go to that. But if it's like multiple districts all at once, it's going to go to the federal circuit. It's, you know, everybody else, the IRS as well. The IRS can take you to district court or they can take you to federal claims court. It depends. Most people, it's a real simple flow, though, to keep things simplified for the judicial process. But anyhow, going back, so there you go. You've got a lot of different federal courts. It's not just district, appellate, supreme, as you can see. Now, how does one become a judge? Well, you have to be chosen. You have to be selected. You have to be drafted. Not really. But party identification, as you can see, and ideology plays a role. Not surprisingly, conservatives tend to lean towards judges who tend to be conservatives. Or Republicans tend to support Republican judges. There's all sorts of stats and studies that have been done. You know, but generally speaking, Democrats are more likely to make liberal legal decisions, and Republicans are more likely to make conservative legal decisions. Now, I do need to point out something, and there was an asterisk in the little bit at the bottom of the page in your book. When I say a liberal decision, according to your book, is one that favors a civil right, a criminal defendant, or an economic regulation. A conservative ruling, by the definition used in your book, is one that opposes the civil right or regulation or supports the prosecution. So that's a pretty broad definition, if you ask me, because, you know, if you want to think about it, you know, historically speaking, and this goes back to what we said previously, you know, we have this image that strict constructionists, people who take the Constitution like word for word, are conservatives. But if you think about that, that would mean you have this absolute commitment to freedom of speech, because freedom of speech is in the Constitution, isn't it? And now we all know that's not exactly how conservatives roll. Conservatives tend to frown upon certain forms of protest and demonstration and this and that and the other. So again, that's why I think it is a little tricky, because if you think about it, conservatives clamping down on freedom of speech sounds a little weird, but that's just how it's all lined out. Long story short, a conservative or Republican judge is going to make a ruling that would probably make conservatives happy. A Democratic judge is probably going to make a ruling that's going to make liberals or Democrats happy. Shouldn't be a surprise. Like we talked about with politicians, people choose their political party based on their belief set. If you believe a certain way, you're going to join the political party that believes that way. And if you're a judge, you're going to rule that way. Now, I do want to point out, though, ideology is not everything, okay? there are a lot of other decisions at play, or a lot of other factors at play, I should say. All right? You have to take into account precedents, other court rulings, how the arguments are presented. The devil is in the details, gentlemen. Right? It's a court case. Judges have to rule on what is presented to them. They can't just go on their gut or their feeling. They've got to be able to base their ruling on something. And some of you are like, no, you're the Supreme Court. Nobody can touch you. Okay, not the Supreme Court. Go to anybody below the Supreme Court. You've got to make whatever ruling you make stick, because somebody can call foul, they can throw the challenge flag, and it'll go to the Supreme Court. And if you made a garbage ruling, you're going to get called out in front of God and everybody. And so as a judge, you've got to make your ruling based on the facts, on what is in front of you, not off what you believe or what you want. And so that's another reason why you can't just assume a conservative judge is going to make the ruling that conservatives want. Because it's all about what is the actual specifics of the case, how was the case presented, what evidence was presented, what are previous rulings. Judges are loath to go completely against precedent. That's the whole reason we have precedent, right? And that's the mistake some presidents have made. They've made these promises, and they name these judges, and they forget those judges are not bound to do what they want them to do. They don't work for the president. They got a job thanks to the president. Theodore Roosevelt appointed Oliver Wendell Holmes to the Supreme Court, only to remark later, and I quote, "I could carve out of a banana a judge with more backbone than that," referring to Holmes. Holmes, by the way, said he did not give a damn what Theodore Roosevelt thought. Richard Nixon told the American people when he ran for president he was going to end busing, right? That way that we were trying to forcibly integrate the schools. He appointed Warren Burger to the Supreme Court. Burger is the judge who made the ruling that upheld school busing or court-ordered busing, right? Another Nixon appointee, Harry Blackmun, was part of the Roe v. Wade decision, which upheld abortion, right? There was another example that we've talked about previously in this class. There was that court case where Roe v. Wade could have been overturned. Several judges that were appointed by Ronald Reagan, Mr. Conservative Hero, they were on the side voting to uphold and continue Roe v. Wade. So just because a judge has got an R behind their name doesn't mean they're going to strike down abortion. Republican judge, I'm completely, Roberts. Justice Roberts was on the side that upheld Obamacare when it went to the Supreme Court. Okay? So, and on the other side, you have had cases where Democratic judges have sided with their conservative colleagues. All right? And so you can't just predict a judge's vote based off their political ideology. Now, up until fairly recently in American judicial history, the Supreme Court was awful waspy and awful male. Okay? For the longest time, most federal judges were white male Protestant and usually had been a judge somewhere else at some point. There has been a little more diversity slipping in there. I will say there has been a decline in the number of Supreme Court justices that come straight from private law practice. That is one thing, especially early on in American history, if you think about it. We didn't have a whole lot of courts, and so we didn't have a whole lot of opportunities for one to be a judge before they went to the Supreme Court. So you had some people who went straight from lawyer to Supreme Court judge. That is very rare. Almost every person who sits on the United States Supreme Court has been a judge at some sort of level, usually for a number of years. So they've got some experience under their belt. Now, for example, 9 justices chosen by Franklin D. Roosevelt, only 2 had been judges. Okay, only 2 of 9 had served as a judge previously. Meanwhile, the 12 who'd been nominated by Ronald Reagan, George H.W. Bush, Bill Clinton, George W. Bush, and Barack Obama, 10 had been judges. And again, it has gotten a little more diverse over the years. Here you go. The number of, and these are the federal judiciary appointments, not the Supreme Court, federal in general. You'll notice, starting with Jimmy Carter, He nominated over 14% of his nominees were female for judgeships. Similarly, around 14% of his nominees were African American, and the number of Hispanic nominees has slowly grown to where, Mr. Obama, 11%. But here you go. Right before him, Republican President George W. Bush, 10% of his nominees were Hispanics. You will notice that the leaders for nominating African Americans, Democrats, 14, 17 and a half. But George W. Bush, 7%, and his father, roughly 7%. A number of female appointees, the Bushes were up near 20%. So yeah, and Obama was, he was all about nominating women, apparently. But you can see that's just dramatic. That's the reason I said it that way. I don't have a problem with female judges. Wow, that's a jump, man. Like he was like, nobody's touching me. But you can see that, it has been I'm not going to say steady climb, a steady increase, but it's a market increase. And on the whole, we have slowly increased the percentage of African American and Hispanic nominees. So the judiciary is getting more diverse. Now, diversity and all set aside, okay, there's the whole, beyond who we're picking, how do we actually do all this? Okay, and this is something we briefly mentioned previously. First of all, as I said, these people are qualified. All right, nobody gets nominated for a federal judiciary position, as a favor, right, or just for giggles. These people are qualified, okay? Even though they are approved or disqualified based on, the Senate's opinion of their qualifications. But there is a tradition of what is called a senatorial courtesy, right? Which basically allows the senators from a state where a federal district judge is to serve kind of an undue influence. They are basically, the Senate will not confirm a district judge if the senior senator from the state where the court is located doesn't like it. Okay, they can submit what's called a blue slip. They basically submit a piece of paper, a form. It is colored blue, hence the term blue slip. They will submit a form to the Senate Judiciary Committee registering their dislike or reason why they don't want that judge to be appointed to a position in their state. And they will usually submit some sort of reason, okay? That usually kills the nomination, all right? It is done as a way of sort of showing respect to senators. Again, think about it. It is the federal district court in your state. You're going to deal with this person, right? You're gonna lock heads with this person. We need a healthy relationship between you two. I'm not asking you all to be buds, but we're asking you all to get along, right? And if there is a real issue at hand, a senator can say, yeah, look, it'd be best for everybody if you pick a different person. There's a lot of districts out there. Send them somewhere else. It could be something truly like this person ruled against me in a previous case, or, this person and I locked heads in business many years, whatever it is. What it has turned into is it's turned into a form of filibuster. See, it went from the old tradition of respect to it's a way of squeezing the president. It's gotten to where basically senators have started to say, look, I'm only going to approve your nominee if you do this for me. So, for what that's worth. Of late, the biggest issue if you're a president is the old litmus test, right? As of late, if you're a president, you are less worried about a blue slip submission, and you're more worried about the litmus test, which is basically a test of ideological purity, right? We're trying to, and it takes its name from litmus paper, right? The paper that determines if something is an acid or a base. It's like a yes or no sort of test. There's no meh. Well, I guess it is meh if it's neutral, but let's be real, judges aren't neutral. Okay? The idea of determining if one is truly a Republican or a conservative, if one is truly a liberal or a Democrat, right? I mean, that's what happens in these hearings. I don't know if anybody watched the hearings for Kavanaugh, let's say, especially not where they went off about the whole accusation, but just looking at a person's background. And there are some of these you can also see if you're really in the mood, on YouTube. There was one part, and I only bring this up. There was a with Scalia. Scalia was a Catholic, and they were basically kind of bringing up him being a Catholic and how that's going to affect things. And he made a quip about that's like saying that there's a Catholic way to cook a hamburger. He basically just kind of said, look, my religion does not affect the fact that I have a duty to the law. It was a good comeback. Scalia was quite quick-witted like that. But there seems to be this whole, hypothetically, what would you do? Or, in this case, you did this. Why? And it's like, dude, they write rulings. But anyhow, there's this real push to try and determine, are they going to rule the way we want them to rule? I mean, that's really what it comes down to. Senators are trying to guarantee this person's going to rule the way we want, right? This person is going to give us the rulings and the decisions that we're looking for. This person is going to push the action of the court in the direction that we want them to push it. Again, it all started with Louis Brandeis. I've already hinted at this. Those confirmation hearings started when Louis Brandeis was nominated for the court. He's from Louisville originally, but he was Jewish. He was the first Jewish nominee for the Supreme Court. And basically, anti-Semitism in the United States Senate was like, we need to review this guy, and they have the right to do that, right? And they started this process, which has turned into a three-ring circus, in my humble opinion. And by the way, I meant to point out this litmus test. Some of you might go, "This is ridiculous. Who cares?" It goes back to the whole, you have this majority on, and I'm not just talking Supreme Court. Some of you who are a little more in tune with some of the events might know about the Ninth Circuit. The Ninth Circuit, which is out west, the far western court, it is far more liberal. It's got a lot more liberal judges on it. And it just turns out that vacancies occurred during Democratic presidencies. And that's where, especially the last couple of years, if there's something involving, President Trump, like his immigration ban or whatever, if they want to bring a lawsuit, if they want to get something before the Supreme Court or something kicked through the federal court system against one of his decisions, they take it to the Ninth Circuit, because the Ninth Circuit is, I don't know, like 14-9 liberal. That's why this litmus test exists, because if you want to change that, let's say there's a vacancy on the Ninth Circuit, right? Republicans want to start to get more conservative judges on that Ninth Circuit to bring it more into balance, because they're tired of the Ninth Circuit being a shoo-in for a liberal decision. They got to make sure that you're a conservative through and through and through. And they're going to ask you a billion questions. And of course, the one that everybody talks about, especially with the Supreme Court, is abortion, right? Both sides are struggling to guarantee that they get the judge on the court who they basically ask them point blank, if there's a case involving abortion, what are you going to do? Because that's the one that they want changed. And it wasn't supposed to be that way. The idea was we're supposed to make sure you're a qualified judicial individual. And now it's like they're basically trying to stack the deck. They're trying to pack the court almost. And really and truly, with this argument over abortion, it has made the litmus test quite difficult. And it's easy to create a filibuster against nominees for the court, right? It takes 60 votes to end a filibuster. And let's face it, it's rare for one political party to have 60 votes these days in the U.S. Senate. And so it's really easy to have a filibuster against a nominee for the Supreme Court. And while the Senate could theoretically prevent filibusters on nominations, they've never passed that rule, right? But as I think I mentioned previously, in 2005, a group of 14 senators, 7 Republicans and 7 Democrats, called the Gang of 14, agreed that they would end filibusters, if there was one, unless there were extraordinary circumstances, right? So 14 senators basically banded together and said, look, we're not going to allow judicial nominee filibusters unless it's absolutely critical, right? That lasted for a few years, right? And it made possible things like Samuel Alito being named to the Supreme Court. They still only had about 60 confirmation votes this way, which is still more than, the average of 50. It didn't last, though. In 2013, Senate Majority Leader Harry Reid of the Senate Democrats changed the rules. This is the old nuclear option that basically said all you need is a majority vote to move forward with a judicial nomination, not for the Supreme Court, but for just lower courts, right? And that passed. Senate Republicans unanimously opposed it, but it passed. But it came back to bite them, right? The Democrats were really, really upset that they made that decision. It sounded like a great idea when Barack Obama was president, and then they lost the 2016 election, and they were like, yeah, that wasn't a good move, because it basically gave Donald Trump the ability to force judicial nominations through. Well, and the Republicans, excuse me. As I said, the litmus test, though, is huge with the Supreme Court because there is no senatorial courtesy. There's no blue slip, right? There's a blue slip for everybody else. But for the Supreme Court, no. There's no way you can politely stop it. It's going to go before an entire debate, right? You're going to have the entire Senate discussing it, debating it, working through it. Now, speaking of the Supreme Court, okay? Of the 160 Supreme Court nominees presented to it in its history, and actually that number is incorrect. It'd be 161 now, I believe, because your book was written before, actually it'd be probably 162, because your book was written before the most recent two under President Trump. 36 have failed to be confirmed, okay? The 36 have failed to be confirmed. From the presidency of Harry Truman through the first term of Barack Obama, 29 of 34 were confirmed. Of the 5 who have not been confirmed in that time period, 3 of them, 2 of them from Richard Nixon and 1 of them from President Reagan, were voted on and rejected. So 3 were actually voted down. 2, 1 nominated by President Johnson and 1 nominated by George W. Bush, withdrew before a Senate vote. So they actually began the process and were waiting for a Senate vote, and they withdrew for one reason or another. But still, 29 of 34 in the last 60 some odd years have gotten through. Now, what would keep one from getting through, right? Is it just the litmus test? Not exactly. You have to realize that some of these fights are not just going to be litmus tests, there's baggage. I think I mentioned Robert Bork, who was the Reagan nominee and was turned down. I think a lot of that went back to his role with the Richard Nixon era. And that he was like super duper conservative. Like he was beyond conservative compared to a lot of people on the court. And liberals were like, no, like we're not going to have a guy who just refuses to even consider the other side. Other people try and find ways to avoid the litmus test that's thrown out there. For example, when they tried to get David Soder to discuss abortion, he refused. He refused, and he argued, I'm not going to discuss matters on which I might later have to make a judgment on. Right? You're not going to paint me in a corner. You're not going to make me say things and then hold me to them. Right? I'm a judge. I need freedom to move, to take the case as I see it. Clarence Thomas, he tried to avoid the litmus test to say he had not a formed opinion on a prominent abortion case because none had ever been before him. He kind of said, look, don't ask me to make a decision on a case I've never seen, or I've never had to even think about this. I have not really sat down and thought about the issue. And now you're asking me to make a ruling on it? That's not fair. So, there are ways to avoid kind of being pinned down and painted in a corner like that. Other people deflect, like I said. Scalia, famously, there's no Catholic way to cook a hamburger. Some people try and find ways to diffuse the situation. Others refuse to play that game. It's an interesting game that they play, though. I will say, reason for rejecting you, it could be the fact of we look at your record and we don't like what we see. Think about it. If you're a senator and there's this nominee who has historically ruled a certain way in certain types of cases, and you think that that's a big issue, that's a reason not to go with them. It doesn't just have to be abortion, is my point. That's not the only litmus test. That's like the primary litmus test, but there are others. Now let's look at the jurisdiction of the courts. Okay, enough babbling about how one gets on the court. Let's say you get on the court. What are you going to do? Well, first of all, America's court system, we have a dual court system. We have a state court system and a federal court system. And this makes things really, really difficult. Right? Kentucky has her own court system. We have a Kentucky State Court of Appeals. We have a Kentucky Supreme Court. Just like the federal court system has a Court of Appeals and a Supreme Court. So we've got two court systems working at the same time. Now, fortunately, we do have some rules about which cases go directly to federal court and which ones go to state court and which ones end up going to federal court after they go to state court and at what point they do that, et cetera, et cetera. All right? It's called jurisdiction. All right? Now, we do know that the federal courts, there are a handful of cases that start in federal court. Most things go to state court first, but a handful of cases arising under the Constitution and the laws of the United States and treaties, federal question cases, and what are known as diversity cases, which means cases involving citizens of different states, those originate in federal court. Okay? If it's this kind of case, it's going to start in federal court. You never see a state court in this case. If I am suing somebody in Ohio, then it's going to start in federal court because the theory is you're not going to let Kentucky court hear it, you're not going to let Ohio court hear it because they'd be biased towards their own citizen, most likely. So the theory is it's going to go to federal court first. And then there are, again, constitutional questions. That's going to go straight to a federal court. Some kinds of cases can be heard either one, right? A lawsuit involving more than $75,000 can go either to federal or to state court, as long as you're both in the same state. If someone robs a federally insured bank, right? Somebody robs a bank in the FDIC. They have broken both state law and federal law. They could be prosecuted by either or by both. And there's become a system in which we decide where you're going to be prosecuted or where it's going to be tried. In a case of, let's just say, bank robbery, let's say you rob a federally insured bank. Usually what happens is they're going to send you where conviction is most likely and where the tougher penalty is most likely. And or. Right? So if it looks like you're going to do more time because of the state laws that you broke, they'll let you be prosecuted in state court. If it looks like you're going to get a stronger penalty from the federal charges, they're going to send you to federal court. If it looks like you've got a stronger sentence in the federal court but less likely of conviction, they're going to send you where the conviction's guaranteed because they don't want to lose the case. So there are times where you might end up going to either or to both. You never know. Some people get tried in both. For example, in 1992, I remember this from my childhood, 4 Los Angeles police officers were accused of beating Rodney King brutally. It was on video camera, actually. And they were tried in California State Court and acquitted. They were then prosecuted in federal court for violating Rodney King's civil rights. This time, 2 of the 4 were convicted. This is what we call a dual sovereignty case, right? Because, again, they could be tried in 2 levels for the same crime. The Supreme Court has upheld the doctrine, by the way, of dual sovereignty on 2 grounds. First, each level of the government has the right to enact its own laws. The concept of somehow the Supreme Court could say that Kentucky law is not important enough to be enforced. That would be, that would be disrespectful, for lack of a better term. And it's not Kentucky's place to tell the federal government they're not allowed to enforce their rules. The second reason, neither level wants the other to be able to block prosecution because of sympathy. The theory that somehow the federal court, and here you go, this is just, work with me for a moment. Let's say that there was a friend of Donald Trump's who was in trouble in the state of New York, and Donald Trump was able to get that person just to be charged in federal court where the case was flimsy, right? The federal case is flimsy. And Donald Trump basically was able to rig it through his politics. I'm not saying this happened. To where the person only stood trial in federal court, avoiding the state court trial, right? Because if we didn't have a dual system, it's either federal or state. It's either or. It's not both, right? So let's say Donald Trump rigs it to where you never go to state court where you're guaranteed to be convicted. He gets you tried in federal court where you got a fighting chance using his connections. That's why our founding fathers built it this way. They wanted to make sure one could not use their political and judiciary connections to help protect people from prosecution in state or federal system, right? And another example, like Southern lynchings post-Civil War, you know, if people were just tried by the state of Mississippi and found not guilty, well, yippee skippy. The idea is no, you still have to worry about a federal prosecution. Just because you stood trial in state court where it was rigged doesn't mean you get away with it. Now, as I said, some matters are exclusively under the federal court system, though, and so you're going to go straight to federal court. You don't get the dual system. Most federal cases, gentlemen, I will say, though, start in a district court. Just because you committed a federal crime doesn't mean you're going straight to the United States Supreme Court. You're going to go to one of these federal courts first. Matter of fact, the bulk go to the federal district court. I mean, some people, like, let's say you violated an FCC rule, you're going to go before this court first. Like, you broadcasted something on TV or radio you shouldn't have done. You're going to go to the court that hears FCC issues. You're not going to go straight to the Supreme Court. If it's a case involving two states, it will, right? I mean, that's an example that goes straight to the Supreme Court. Sorry. But outside of that, let's be real. You're not going straight here. You're going to go to one of these. And the bulk go to district court. For most federal cases, they start in district court. Because if you think about it, that's where a lot of the issues, you know, the way that they're heard. It's basic federal crime, civil suits under federal law, civil suits involving more than $75,000, bankruptcy court. A whole lot of things end up going to district court first, right? IRS cases, generally speaking. Here you go. This was the list I was rattling off. A lot of things are going to start in district court, okay? Sorry, I realized I misspoke a moment ago. If you're unhappy with something that the federal agency that is the FCC are ruling, you go straight actually to a court of appeals. I don't know why I said district court. I apologize. You are appealing a decision of a federal regulatory agency which is located in multiple states or enforces its rules over multiple states. Therefore, it's a case involving multiple states. It's going to go to the Court of Appeals because there is no one district it could go to. I apologize. I misspoke. But most cases start in district court, okay? Please ignore this very confusing diagram. Let's start here. Let's go here. Most cases are going to go here, right? Yes, U.S. regulatory commissions like the FCC, if you're unhappy with what they do, it's going to the appellate court. Things like the international court, you know, international trade court, claims court, tax court, yeah, they'll go there. But most cases start here because if you think about it, first of all, the only way you're going to go to appeals court is somebody is appealing a lower level decision. See, that's the thing that I don't think that this diagram conveys properly. See, somewhere a decision is being made, right? U.S. Tax Court, U.S. Court of Appeals, all of these are courts, and then these are agencies. So all of these are government institutions that already made a ruling on a decision, which is why all of these end up going straight to an appellate court because a decision was already made. In order to go to an appellate court, you're appealing a previous decision. Somebody's got to make a decision. So there's got to be the original case. So that's why a lot of things start in district court. Your first trial for a federal crime has to take place in district court, generally speaking, Generally speaking, there are, I guess, a couple maybe examples that might go straight to Supreme Court, but let's be real. By and large, you're going to start down here, right? Bankruptcy court, right? Lawsuits involving more than $75,000. All these are going to start in district court. District court is overwhelmed, gentlemen. In 2009, 667 district court judges received 276,397 cases, more than 400 per judge, more than 400 cases per judge per year. Most of these, though, thankfully, are straightforward. Most of these are just, you look at the case, you make a ruling, right? It's just, you had to hear it because it's your job. Not a lot of these are groundbreaking civil rights kind of things. Very few of these are ever going to lead to a new public policy, a new law, a change in America. I mean, it's you committed a crime, you're guilty, or you're not guilty, done, right? Cases that do somehow affect the Constitution or a law can start a chain reaction, right? And can eventually work their way up, right? The Supreme Court, all right, so just because you go to appeals court, right? All right, you go to appeals court. Let's say you're unhappy with appeals court. Just because you're unhappy with appeals court doesn't mean you're going to go to the Supreme Court. There are a few cases that will go to the Supreme Court. There's no choice. If two states have a case, it's going to the Supreme Court. If it involves the United States and a state, it goes to the Supreme Court. Foreign ambassadors goes to the Supreme Court. And a state and a citizen of a different state, right? As I've already said, that is a case that will go to the United States Supreme Court. Outside of that, though, there's no guarantee you'll go to the show. The Supreme Court only hears the cases it wants to hear. That's right. They pick and choose. Okay? Excuse me. At one time, there were certain cases the Supreme Court had to hear on appeal, but Congress changed that law so the Supreme Court can pick what it wants to hear. It does this by issuing what's called a writ of certiorari. Okay? Certiorari is a Latin word roughly meaning made more certain. So they write a paper, a cert as it's known. They write, a writ of cert, basically asking to hear more about the case. Okay? And so what happens is the Supreme Court gets all these petitions, 7,000 roughly. Every year, 7,000 cases appeal to the United States Supreme Court. The justices review the general petition, right? It's just a vague cliff note, so to speak, summary. If 4 of the Supreme Court judges feel this is something they should tackle, they issue a writ of certiorari, which basically starts the process of your case getting fully reviewed by the United States Supreme Court. Okay? Now, generally, what the Supreme Court does, okay, when they're trying to do this whittling down process, here's what they usually look for. They ask themselves, is it a case where the federal court had a different ruling than the state court? Is there a significant constitutional question, right? Those are the things they're going to look at. They're going to look at, do we have a disconnect between state court ruling and federal court ruling? Or is this a constitutional question by and large? Those are the cases they want to hear. They are not going to generally take your death row conviction, okay? If every court that's heard your death row conviction has upheld your death row conviction, you're going to stay on death row. They're not going to take your case. They're not going to overturn every single court in the United States of America for you, right? Now, as I said, here you go. If 2 or more federal circuits have decided the same issue in different ways, that's another case. They're going to look and see, has this type of case made its way to the federal courts before? Have 2 different federal circuits ruled differently? That's a time that we're going to take it up, okay? Or if they feel that the state court has somehow violated the Constitution or upheld a state law that is in violation of the Constitution. Okay, these are all the things they're going to look at when they decide if they're going to issue a writ of certiorari. They kind of have a checklist, right? They rarely accept more than 100 cases for full review. Now, this is where, for those of you who are like, this is garbage. Well, think about it. If I'm the Supreme Court, I have to think about what I'm doing, right? If I grant too many writs, I'll be overloaded. I will be truly overwhelmed, and I won't be able to give every case its due time and consideration, right? The court's workload has quintupled in 50 years, right? The court's workload over the last 50 years has grown dramatically. Now, if they only rarely hear cases, then they're allowing the Federal Appeals Court to be the final say in this country. And basically the Supreme Court is giving away their ability and their authority and their power to interpret American law. Now, there are 12 federal courts of appeals staffed by 167 judges. There's a good chance that those people don't all agree. There's a good chance the Ninth Circuit and the Fifth Circuit rule differently, right? They have different interpretations. The reason I mention that is the Ninth Circuit is that far western circuit that's known for having a liberal makeup of judges. Meanwhile, the Fifth Circuit, which is Texas, Louisiana, and Mississippi, a little more conservative. It actually has nothing to do with where the court is located. It has to do with who the judges are, but it tends to be a more conservative circuit. If every time you turn around there's some sort of issue and the Ninth Circuit says one thing and the Fifth Circuit says another, we need consistent application of law in this country. Right? We can't have it to where if you do something in Texas, it's handled one way. If you do the same thing in Oregon, it's handled a different way. That's a problem. And so that's why the Supreme Court sometimes has to jump in. You know, they have to make sure that law is fairly and equitably used in this country or enforced in this country. All right? The Supreme Court reviews only about 1 to 2% of appeal court cases. But again, they're really only looking for times where there have been contradictions, right? They are going to weigh in and rule on a case if they feel that they need to settle a dispute, all right? Now, and that is where, again, Judge Thapar will say, he actually deals with more than the Supreme Court. The only time the Supreme Court's going to question him is if another federal appellate judge questions him, really, right? Now, because of their incredible workload, honestly, that means Supreme Court clerks do a lot. Honestly, clerks, in some ways, are making decisions for the Supreme Court. These clerks, who are graduates of law schools, basically doing an internship for a Supreme Court justice, they are helping, write the briefs. They are helping organize the case file for the judge to review. They might even help the judge write their decision, draft it, which means these clerks are playing a far greater role than a lot of people realize. But we'll get back to that. All right, let's get our case to the court, sir. All right, let's get your case to the court. First of all, I know some people are going to go, it's ridiculous. 96% of cases never even make it there. Yeah, it's not because of cost. You do have to pay $300 to apply for a writ of certiorari. You also have to make copies of your petition. But you can get an informa pauperis. Gideon versus Wainwright, the guy who actually famously applied for his writ. He used paper from the library in the prison he was in. I'm sorry, I had a brain fart there. He basically pointed out he had not been provided a lawyer. Gideon was the start of your Miranda rights. But Gideon pointed out that he had never been provided a lawyer because he was poor and the state never provided him one and no one told him that he had the right to one. And he appealed his conviction, basically saying, I didn't have legal representation at my trial. He actually applied for his writ on paper provided by the prison, and he was granted his writ because he basically, I have no money. But America does not believe that you should be denied justice because you're poor. Let's be real. If you're poor, somebody will pay for it, right? Interest groups, If it's a case involving civil liberties, the ACLU will pick up the tab, all right? All you got to do is contact them, pay for a stamp, make a phone call, right? explain your situation. They'll pay for it, right? If it's involving civil liberties, the ACLU has got you. If it involves the Second Amendment, the NRA's got you, okay? Somebody's going to pay for it. So don't think that people don't get to go to the Supreme Court because they're too poor. That's not going to happen. I want to point out, interest groups don't just pay the bills. Interest groups, in many cases, help determine what's going to get to the Supreme Court because they go around. Right? They find cases. They motivate people. You know, Rosa Parks didn't wake up one morning and say, I'm not getting off my seat. Forget this. Rosa Parks was kind of recruited to do what she did, right? The NAACP had been shopping around trying to find people to do stuff because they were like, look, we just need somebody to break a law so we can have a court case. The Scopes monkey trial, John T. Scopes was basically told to do it by the ACLU. Mr. Scopes did not wake up one day and say, I'm going to teach evolution, watch this. Scopes did it because the ACLU told him to do it. They told him they'd pay for his lawyer. They told him they'd pay whatever legal fees he incurred and any fine, okay? What was I going to say? It wasn't, well, actually, that's the other thing. Rosa Parks was not the first woman. Rosa Parks was not the first one to sit on the bus. There was actually a girl who did what Rosa Parks did before Rosa Parks did it, but she was an unwed pregnant girl. And the NAACP felt that nothing would hurt their case more than giving racist the ultimate stereotype, which is the teenage pregnant black girl, right? You know, they were like, that is the last thing we want to give the white races. Our client is a 17-year-old pregnant black girl, right, who doesn't know who the father of the baby is. And so that's why they would not take her case, but a couple months later, they did take fairly straight-laced Rosa Parks' case, right? So interest groups are going to help determine who gets their case to the Supreme Court. They're not just going to pay the bills. They shop around, they promote it, they float out ideas, they recruit people. Like I said, John T. Scopes with the evolution case, things of that nature. Now, one thing too, fee shifting. What is fee shifting? Unlike what happens in most of Europe, okay, each party has to pay its own way in this country. All right? If you want to go to court, you are paying to go to court. In England, if you sue someone and you lose, you pay the winner's court costs. Right? In England, you got to think before you sue, because if you sue and you lose, you not only are on the hook for your legal fees, you have to pay the other person's legal fees. Right? Basically, you have to pay the cost that they went through defending themselves against your silly lawsuit. We don't have that problem in America, which is why suing people has become quite fashionable in our country in some regards. You know, you're on the hook for your legal fees. If you lose, you're not on the hook for theirs. If you win, you get a settlement, right? Laws have made it, though, to where we have what's called fee shifting. We have a number of laws that have made it to where the party that initiates the lawsuit can collect the costs from the defendant if the defendant loses. In certain cases, right? In certain cases. Not all, but in certain cases. And for those of you like, but you just said you win the judgment. Let's say the judgment isn't that great. And maybe I went through a whole lot of time and effort. Maybe the judgment is the exact cost I had to go through the lawsuit. I didn't win anything. Fee shifting allows me to collect not only the judgment, but my legal costs. So I actually get the judgment, right? For example, if a corporation is found to have violated antitrust laws, it must pay the legal fees of the winner. If an environmental group sues the EPA and wins, the EPA pays for the legal costs, right? Now, there is one negative side effect to this. It's made it cheaper and easier to go to court, at least for certain cases, which means people are more likely to go to court, which means an already overloaded court system is getting more overloaded, right? Now, all right, let's take money out of the equation. Let's say going to court was free. Okay, does that mean everybody gets to go to court? No, you got to have standing. What does standing mean? Standing means you actually have a reason to be in court. You're entitled to go to court. I mean, to define it, the legal rule that authorizes you to actually start a lawsuit. You have to. You can't just go to court because you're mad, right? In order to go to court, there has to be, first of all, a real controversy. This prevents what's called a friendly lawsuit. Basically, you sue a friend to start a court case that might start an appeals process to change a law. You know, there has to be a real controversy. I can't just be taking someone to court because I feel like taking someone to court, or it's part of an ulterior motive. There has to be a real issue here. Somebody has to have actually done something to somebody. You have to, speaking of which, you have to show you've been harmed. You have to be harmed. You're not just upset. Right? I have to show, let's just, for stupid example, I want to sue the state over speed limits. I have to show actual harm from the speed limit. I can't just say I don't like not being able to drive 90. I don't like is not a lawsuit. I don't like a lot of things. It doesn't mean I have a right to take anyone to court for anything. Okay? It just means I have a difference of opinion. I have to show true injury to go to court, right? Merely being a taxpayer does not allow me to challenge a federal government action or a law. You know, I pay my taxes. We all pay our tax. Well, actually, not all of us. A lot of us pay our taxes. It doesn't make you special, okay? And it doesn't mean that you magically get to go to court. Paying your taxes is not a guarantee of your day in court, right? It's kind of like, you know, when students, I pay tuition. Yes, you do. Congratulations, you know, and your tuition pays for certain things. It doesn't give you a right to throw a hissy fit, right? You know, paying your taxes does not mean that you get to sue everybody and everyone or take the government to task anytime you feel like it, right? People have tried that argument and have failed, okay? Now, Congress and the courts have made it easier to acquire standing over the years. Used to be a little more difficult. It's become a little simpler, right? But I do want to point out, you cannot sue the government without its consent. This is known as sovereign immunity. Now, bear with me for one moment before you guys are like, that's ridiculous. If and your book said, let's say the Army accidentally kills your cow while testing a new cannon, right? You cannot sue the government for the cost of your cow unless the government agrees to go to court and have this lawsuit, right? Testing a cannon is legal for the United States Army. And so, you'd be suing the Army for doing what the Army is supposed to be doing. Congress has given its consent to be sued a number of times. A lot of people have, okay? Now, I know some people are like, well, why would the government ever agree to a lawsuit? Think about it, kids. If the government never agreed to go to court, there'd be a revolution. There'd be a riot, right? People would not be happy with that. Think about early American history, right? Shays' Rebellion, things that the government, especially early on, was well aware that you can't just refuse to go to court all the time, right? People will grab their guns and march on the Capitol. And that set precedent. That set the example that our government was willing to go to court. And so if the government went to court about this once upon a time, there's no reason they can't go again. The government usually, also, let's face it, the government usually is pretty strong. If the government knows they're going to lose the case, what are they going to do? They're going to settle, right? The government is not immune, but the government is able to refuse to go to court if it's completely silly. And that's why this exists. This allows the government to avoid going to court every single time somebody tries to sue them for every single little thing. And going back to standing, let's say you do have standing, but it's petty. It's ridiculous, right? The government needs the ability to go, that's stupid. We don't have time for this, right? And so the government can refuse to go to court, okay? And as I said, it's gotten a little more liberalized over the years. You know, you have the ability to go to court a lot more so than you used to be able to, but, you know, not everybody gets their day in court still. One last thing I need to talk about, we'll wrap this up. Again, I apologize, it's a lot. And then we'll get into, on our last lecture of this chapter, we'll actually go inside the Supreme Court, and it's not as exciting as you want it to be. Class action lawsuits. Class action lawsuits, gentlemen, is a form of case in which a case is brought into court by a person or a group of people on behalf of a bunch of people who all fit the same circumstances. Okay? The most famous class action lawsuit in American history, you didn't know it was a class action lawsuit, Brown versus the Board of Topeka, Kansas Board of Education. Brown v. Board. Right? The case in 1954 where Miss Linda Brown won her court case that said she could go to the all-white school in her neighborhood. She didn't have to go all the way across town to go to the black school. Okay? Turns out Brown was one of a number of plaintiffs in a case. It's actually Brown v. Board et al. There were other cases. But, sir, why is it Brown v. Board? Because Brown was the first last name alphabetically in this class action lawsuit. And it turns out that's how we're going to remember it. There were several cases where it was all the same thing. Kid lives down the street from the white school, can't go to the white school, has got to go all the way across town on some epic quest to go to school. Right? This is ridiculous. You've seen a lot of people take advantage of class action lawsuits. Why? Because, first of all, we divvy up the cost of the case. Right? You know, it makes it really easy for us to divvy up the cost of the case. You know, legal fees are spread out over a wide realm. There are thousands of these cases, a lot of them involving civil rights over the years, but not just civil rights. And it's really attractive for the lawyers because when the court rules on these kind of cases, right, they issue a settlement to the group. The lawyers get a percentage of the ruling. There's only a few lawyers. There are thousands, perhaps tens of thousands of people in the case. So let's just say for fun, that the court issues a ruling for $3 million. $3 million to these several thousand people. It's going to be divvied amongst those several thousand people. The lawyers get a third. Let's just say a third. The lawyers get $1 million, right? Everybody else gets, a check for $200. The lawyers each, they get to split $1 million 5 ways. You got $1,000, they got $250,000 or $200,000 or whatever, right? And that's what's happened. Your book gave the example. Let's say that you think the phone company overcharged you $75. You hire a lawyer. Well, you try to. Most lawyers won't take it because there's no money in it. But let's say you realize you and everybody in your neighborhood got overcharged, and you start doing some research. Everybody in your county got overcharged. Everybody in your state got overcharged. Your state scammed everybody in the state out of $75. Well, that could be a few million people. Now you've got some lawyers who are going to take the case, and you guys are going to win your case. And the verdict is going to be the phone company has to give everybody a check, not only for their $75, but another $100 because they were naughty. Several $1 million verdict. But because it's a several $1 million verdict and the lawyers get a certain percentage, the lawyers are going to get $1 million, right? That's why class action lawsuits have become popular. That is why in 1974, the Supreme Court tightened up the rules on these lawsuits. They tried to basically limit class action lawsuits because they realized class action lawsuits were going to get popular. There's one, mesothelioma. Have you seen commercials about mesothelioma, right? Did you work with asbestos? Did you have a relative who worked in a shipyard? Blah, blah, all these things. Those are forms of class action lawsuits. They're basically trying to get you to join their class action lawsuit. Okay? But it's still pretty easy to bring a class action lawsuit. Honestly, it's very easy. Getting to court is pretty easy. right? When you start to look at it all, when you start to look at the fact of somebody's going to pay your cost if you can't afford, or the court can grant you just a waiver if you can prove you truly are indigent and unable to pay for it. Standing has become more liberalized. Now, it's pretty easy to get to court, kids. Okay? And we've made it far easier to enter the federal courts than once upon a time, than early American history for sure. But getting to court is half the battle. Now you've got to win. What happens in the hollowed halls of the Supreme Court, Mr. McCoy? That is your next lecture.